it's time to start now, okay? My name is Marta Fernandez Alarcón. I'm the Secretary General of the Spanish Business Council, and I would like to welcome you to this webinar about the new non-Muslim marriage law. To present this webinar, we have here today one amazing expert, is Ahmed Gabr, Legal Advisor General Law in Elnaggar Partners. I'm not sure about your surname, that maybe I've not I've not pronounced very well. Elnaggar is member of the SBC, and I'm really thankful for the collaboration. We have some international law firms in the SBC, and we are very pleased to have Elnaggar today with us. One of our main goals and our main purposes from the chamber is to be an international community. And although most of our members are Spanish companies, not all of them are, as for example, Elnaggar. With all our members, we are creating an amazing platform to share ideas, to do networking, to find ways of collaboration, and to make businesses in the UAE. I don't want to rest time to Ahmed. I think he's going to explain really well all this subject. So we have our amazing speaker, and you can start now. Please go ahead.
Thank you very much indeed for the introduction. Whichever part of the world you are in at the moment, and on behalf of the Spanish Business Council and Elnaggar Partners, it's my honor to officially welcome you in today's webinar. My name is Ahmed Gabr, and I will walk you through the new non-Muslim marriage law, aka it is the new civil marriage law. And that was came into effect in UAE this February 2023. Speaking of which, we have a very interesting law to navigate today, because from my perspective as a legal advisor, I would say that this law actually removes the restrictions of the current laws and regulations that are usually used to in commencing marriage. I would request to share my screen. So can I have an access to share my screen, please?
Yes.
Thank you very much. Basically, we are speaking about a new law that will bring flexibility to the marriage, to the divorce, to the custody of the children, to whatever transaction follows or fall behind as a result of getting into a marriage relationship. And there are several restrictions to be able to get benefit of this law. And for sure, I would say that this law is the most flexible law I have ever seen in my entire life. And I never saw a flexible terms and articles like this before. So let me share with you what do I feel so that we all on the same page. And yes. You can see the screen. I hope it's visible. Can you just the confirmation that the screen is visible?
It is, Ahmed.
It is visible. Very good. Amazing. So basically, the law number 41 of 2022 concerning the civil personal status, it's actually commenced on February 1st, 2023, and it's basically speaks about the provisions of the civil marriage and whatsoever that might arise after this marriage, often obligations and benefits for both parties. Actually, at this law, there will be no any sort of discrimination, and might be the most common problem that actually are being complained about, that the original rules and regulations of the marriage law. Whereas in this law, for example, that the custody of the children could be joint custody between the husband and wife. Husband always has the right to give a divorce, and in this law also the wife has the right to give a sole divorce. So we have a lot of differences between this law and the ongoing regulations. And let's see what we have exactly. We have 5 chapters in this law. Chapter 1 is talking about the provisions of the civil marriage. The scope of the application of this law means that the provisions of this law shall apply to non-Muslims in the UAE. And by non-Muslims, we mean the residents of the country, expats, citizens whatsoever on this land who is non-Muslim. It must be 2 parties are non-Muslim. So this law is applicable to them in the UAE. Unless one of them choose to apply the law of their home country. And this is very, very strange for me, because the very high flexibility in this article can be very seen when the law gives them, when the regulator gives them the right to choose their own home country. How that will happen, we will navigate this later. The persons governed by the provisions of this decree as named may agree to apply other legislation regulating the family or personal status matter currently in force in the state, instead of applying the provision of this decree law. Means that, however, if both of them are non-Muslim, the parties are non-Muslim, and they still have the option to apply the regulations of the civil personal status law, the one that we are all working with instead of this law, the newly introduced law. And from my perspective, or from my recommendation as a legal advisor, if both parties are non-Muslim, they must apply this law and not any other law. Even their home country law, I trust that it is not flexible as much as this law. Of course, this law would be considered after the entry into force of these provisions. As this term, it says it confirms and affirms that this law shall be applicable to all incidents that happen after applying this law. Means that the marriage itself, so the marriage contract, or the marriage agreement, because in this law, it's actually an agreement, it's an application. This application must be submitted with the competent authorities who are applying this law, enforcing this law, in order to get benefit of this law. Meaning to say that you can't be married before issuing this law, and your marriage was based on the regulations of the country, and then you want to make a divorce based on the provisions of this law. This is actually not applicable. In order to get benefit of this law, you should enter the relationship through this law. So you should use this law to enter into the relationship, into the marriage relationship. So if you married and you have a simple marriage certificate issued in Mauritius, issued in Seychelles, issued in the UAE, both parties are non-Muslim, in divorce or in custody or in alimony or whatever right you are claiming, you can't claim under this law because the marriage was not commenced under this law. Article 2 of this law says and tells us that the Georgian calendar is the way that the durations will be calculated. And just to cut the doubt, it is 365 days and 30 days per month. Article 3 in this law, Chapter 1, speaks about the cases of exception from referral to family guidance. One of the privileges that the law introduces today is whatsoever claim under this law will be exempted from the referral to the family guidance. As we all know, if there is any claim related to any marriage contract or related to any marriage relationship, before doing anything, before referring to the court, and before standing before a judge, the whole matter must be first referred to the family guidance in order for them to associate between the parties and try to amicably found a solution to whatsoever problem it is. However, in this law, there is no need to refer for amicable solution because what was written in the agreement will be enforced immediately at the same day, at the same hour. So in terms of claiming alimony, claiming guardianship, claiming custody, doing a divorce, or claiming whatsoever claim or right, it will not be referred to the committee for the amicable solution or for the friendly settlement. It will be directly referred to the judge, and the judge will not have the authority to decide otherwise than what was agreed in the agreement. The judge will confirm and approve immediately whatsoever was written in this agreement, as long as it's aligned with the laws and regulations of the country. So, divorce proceedings filed in accordance with the provisions of this decree law shall be excluded from being referred to family guidance committees, and instead shall be presented directly to the court to render a judgment thereon at the first hearing. Article 4 of Chapter 1 speaks about the equality between men and women as to rights and duties. And this must be the best article that ever introduced to a law, where we can see there is no discrimination, there is no privilege for a man to a woman. It's totally flexible. It's 100% flexible. And we can start with the testimony equality. The testimony equality is something that absents in the current regulations, because we follow Sharia and we follow the law. The law of Sharia says that the testimony having different measurements between men and women. So the testimony for the man has actually a higher hand over the testimony of the woman. In order to qualify the testimony between men and women, you will have to bring two women to testify against one man. So one man equals two women in the testify. This is in the ordinary regulations. But introducing this law came up with the fact that we agree that the testifying of a man equals to a testifying of a woman, and there will be no discrimination, or there will be no privilege from a man to a woman. This is also something very, very new and something very different, and this is a flexibility. In terms of inheritance, the inheritance shall be equally distributed between men and women. And if we're going to talk about the inheritance regulations in the law, we need a day to speak about it. Inheritance in Islam, inheritance in the UAE, inheritance in the Middle East and GCC and Islamic countries has very strict rules and has regulations from the beginning till the end. And we can't go anywhere but what was written in these regulations. For example, if a man passed away, he has a wife, he has boy children, and he has girl, daughter. So according to our calculations, boy gets full, like boy gets half. First the daughter will get third, and the wife will get quarter, and the boy will get everything. So there must be a discrimination. This is the like, so far I can remember the calculations, but let's say, because there are different positions to receive the inheritance, For example, if the grandfather is still alive, wife and daughter and children, boy, like every one of them has different calculation, and every one of them gets different percentage of the inheritance according to Islam and according to what we believe in. But according to the new law, the inheritance came equally distributed between men and women. So it doesn't matter when or men or women, it will be calculated according to this theory, I think. For example, he passed away, there are 6 people to inherit, then 100 divided by 6, equally for each of them will receive the inheritance, unlike the current regulations. And additional point to the inheritance, both of the parties has the right to agree on the marriage agreement that none of them inherit the other. And the inheritance shouldn't be divided on this way. They can choose whatsoever they want in terms of inheritance. For example, I agree with my wife that my children gets all the inheritance and you get nothing. And she agree on the same or otherwise. This is also allowed. So the principal rule is that the inheritance will be divided equally between the successors. But both the husband and the wife has the right to exclude this and to do like set of terms that have regulating the inheritance later on. The right to request a divorce. Both the husband and wife may demand that divorce be established by the court without reserving to their rights related to divorce. This is also something very new, introduced newly in this law, which gives the right to the wife or the husband to give the divorce from his own will. Like, if we compare this to the regulations now, we will find it very hard. If the wife wants to divorce, she will have to seek the courts. She will have to file for a divorce, for alimony, for guardianship, she will like be blended in 6-7 months of litigation just to get divorced. But with this law, divorce is article of the agreement, of the marriage agreement, and it could be stipulated as follows. The wife has the right to give divorce whenever she decided so, via written statement that I agree to divorce my husband. And by that, if this statement went to the concerned judge, on the same day she will get divorce order. And she saved 6-7 months in litigation, time, money, efforts, and pressure, stress in one day. How awesome is this? Of course, the man has the same right under this law to give the divorce. Same thing, same what was given to wife. Joint custody. We all know that the custody is always goes to the woman, to the wife. And for sure, the custody, this is something I want to highlight in order to understand where the custody right came from. The custody right is not the right of the wife, nor the right of the husband. Is not any of them right. It's the right of the children of getting well raised in an environment helps him to be a good person in the future. It is the children's right to receive the protection and to receive the support needed in his early years. And it's usually will go to the mother, because the mother is the care for the children. She's the one who will care. She's the one who cares more than husband. This is everywhere. But in this law, the custody became joint. The custody that became joint means that both parties can take over the custody right, which belongs to the children, not to any of them. They can carry on the custody right jointly, both of them at the same time. A woman and a man shall have an equal right to assume joint custody of the minor child until the later, means the child, reaches the age of 18 years, after which the child shall have the freedom to choice. In this case, there are 3 or 4, maybe 5 differences between this regulation and the current one, where we can see that the choice age has been changed to equally 18 between if he's a boy or she's a girl, because in the current regulation it's not the same. It's 14 years old and 16 years old. So the equally to 18 years old, the applying 18 years old as the age of choice for the children. And in this case, I think this is very, very, very enough time that the child became grown man and can join college or university. And I think at this stage or at this age, he's mature enough or she's mature enough to make a choice whether to continue with her mother or her father, or to continue as it is and never change anything. Chapter 2 of this law speaks about the provisions of civil marriage, and I think this is the biggest chapter that needs to be digested because it's very informative. We have Article 5 speaks about the civil marriage. And to clarify what is a civil marriage is actually a contract between two parties. Sets out the terms and conditions and articles of their marriage, sets out the obligations of both parties without the need to add anything from Sharia, from religion, whatsoever the religion is, without the need to the religious parts, It's just the civil part. So this is a totally civil transaction. This is not a region transaction or regulations that are very neat to the Sharia or to the religion in the country or religion of the parties. It's civil. So civil means that the civil law applies over here. So for a civil marriage contract to be established, the following conditions shall be met. And definitely one of the conditions, I can't see right now on the screen, but both parties must be non-Muslim. Wife and husband. If any of them is Muslim, it will not be applicable. And both the husband and wife have attained at least 21 years old. In that age, the age is established by an official document issued by the state of their nationality. I think this is very clear. That the marriage shall not take place between brothers, sons, grandchildren, uncles, or aunts, and any other cases specified by the executive regulations. Of course, there is an executive regulations for this law. I'm not recommending to read it because the law is very clear. You read the executive regulations only if the law is not clear. So this is very obvious that brothers can get married to each other, sons, grandchildren, it's same basic rules. Third is that the married couple explicitly express their consent to marriage before the authentication judge, and that there is nothing that legally discredits their consent. So in order to apply this, in order to enforce the agreement, actually applied it, but we need to enforce it before the judge. We also need to give a consent that we are explicitly express our consent to marriage, and that there is nothing to discredit any of us from getting married. Also, the married couple must sign the disclosure form, which is a form that prepared by the court, and they will have to sign it. Any other conditions is specified by the regulations, executive regulations. And for the, I would like to take the chance and also announce that in our firm, in Elnaggar Partners, we are newly using this law. We are providing the services that needed to get into a marriage agreement. We actually doing this. We providing whatsoever needed to get from A to Z. and we will have a set of terms and conditions that will actually be acceptable by any husband and wife. It's very fair, and we can actually amend to whatever imagination of any of the parties that on the way that protects their interests and everything. Marriage procedures may be concluded before the authentication judge with the competent court by submitting an application. And this is the application that I was announcing. This application is actually founded on Dubai courts, on ADGD, Abu Dhabi courts website. You can just download it, read it, and amend it to whatever you want. Because basically what's happening is, we download this application, we will have this, the application has basic information like the names, like the addresses, like information about the parties. And then there must be an addendum to this, or not an addendum, an appendix to this application, which has all true articles that governs the marriage itself, what after marriage, and in case of inheritance or properties or all of the prospect scenarios could be written there, and also all of the prospect solutions could be written there, and that will be pending for the parties. That will be final unless both of them agree to amend any article in this application later on, and that is possible through a written consent to amend this article and submitting to the judge, and it will be amended and so on. So it's basically, I can feel it's like you're establishing a company. I can feel it's the same. You're establishing the company. All parties have agreed to all what was written in the Memorandum of Association, and you're operating. And within the Memorandum of Association, there are actually articles governs the company before establishing, during and after, and in separation, liquidation, in whatever will happen later on, it will be written there. And also you have the right to amend the articles of the memorandum. So I believe that this is a partnership more than a marriage contract. The marriage shall be established by the married couples filling out the form prepared for this purpose, the form which we get from the website, before the authentication judge. And the married couple has the right to agree on the terms of the contract, and both married couples shall invoke the provisions of this contract concerning the rights of the husband and wife during the marriage period and the post-divorce rights, and in particular, the joint custody of the children. This is super flexible. The marriage contract shall include a disclosure by each married couple of the existence of any other prior marital relationship established by either of them. Means that either the husband or the wife had a previous experience or had a previous relationship that must be declared in this form. It's the right of the husband to know if the wife has previous married, and it's the right of the wife as well to know the status of the husband. Indicating the date of divorce for the ex-relationship, if any, and the wife's acknowledgement that there is no existing relationship, taking into account that the husband shall submit this acknowledgement if his legislation does not allow him polygamy, and that in all cases the husband shall disclose any existing marital relationship before the authentication judge to the better understand if there was any past relationship for the husband or for the wife that should be recorded and that should be included in the disclosure before the judge, because this is the right of both parties to purely understand that the past in terms of the relationship. The contract shall include proof of consent of each of them verbally or in writing. And my recommendation as a legal advisor, everything should be in writing in these terms. And for sure, this is something also new, that the bilingual contract will be accepted by the judge. As far as I remember, we did this one time before on an application that it was bilingual and it was approved, meaning to say that you don't need to formally translate it unless you did it outside the region of the courts. Means that if you will just sign the application you receive from the court, this application is already bilingual. If you will add an appendix to this application and it's bilingual, or you decided to make it bilingual, then you must have a translation stamp on it. Chapter 3 has the divorce and its procedures. And speaking about the divorce, that means that we should digest the procedures of marriage, of getting into a marriage contract. And I think that was very obvious. And definitely the section of Q&A, I would love to hear your questions in case chapter 2 and chapter 1, there's something mystery still. Divorce by the sole will. In order for the court to pronounce a judgment of divorce, it shall be sufficient for either of the married couples to express his or her wish to get separated and not to continue the conjugal relationship. This actually indicates to what we have mentioned before. I mentioned that the divorce could be asked by the wife or by the husband by her own free will or by his own free will. And you don't have to go through years or, months of litigation just to get a divorce order from the court. So once you pronounce to the court that once you express to the court your desire of getting divorced, the court will immediately do the divorce without asking the reasons. It says it shall be sufficient for either of the married couples to express his wish to get separated and not to continue. So that's all what you have to do, without having to justify the desire, without specify the aspects of harm, or to lay the blame on the other party. So in this article, there is actually a huge flexibility in terms of getting divorce on spot. Means that currently, and aside from this law, in order for the wife to get divorced, for example, if we choose any reason, let's say aspects of harm, well, if she decides so, and if she decides that this is the reason for divorce, she actually needs to clarify what are the aspects of the harm. And that might be not an easy option, because most of cases based on the harm are actually based on the reasons of the husband, let's say, is assaulting his children, assaulting the wife, and if actually she doesn't have a proof of that, she will not get divorced based on the harm. Harm actions requires counter actions, immediate counter actions from the wife, like calling the police, like issuing the police report, and define everything there. Even the wife will not do anything with the report, and she will drop it later. Even she doesn't have the desire to sue her husband for this reason, for beating her or something, but she must have an evidence of the incident, that she was bitten, that he threw a glass in his face, he damaged her, whatsoever happened. That should be added to a police report, because later on things are getting worse, and later on you will need a piece of evidence to get rid of what you are passing through. Divorce procedures are actually, we can summarize it in the last two words, is duly notified. The divorce procedures are very simple and very easy. Upon the request of one of the couples, and the divorce will occur, and it will take action once the other party is notified, and that's all. You have nothing else to do, and the court actually notifying notifying the other party. It's not the obligation for you as wife or husband to notify your partner that he got divorced or she got divorced, but you pay extra dirhams like 75, 80, and the court will take over the mission to notify. The alimony is also a subject that's very, very important, and there are a lot of questions in this regard, either in the current law or the new law. The divorced woman, and of course the alimony is only an exclusive right to the woman, may submit a request to the court after the judgment granting the divorce is rendered, seeking a judgment of alimony from her ex-husband, and any claim subsequent to divorce before the court shall be added in accordance with the form prepared for this purpose. We're going to say that if you are following the articles and you're following the flow of the article, you can see that in every and each article, they are making sure that you read to this part, which is shall be added in accordance with the form prepared for this purpose. They want to deliver this very important point, that whatsoever you wish to do in the future, please include it in the form. Whatsoever you wish to receive in the future after divorce, please have agree in the form, have agree in the application. And that's why I'm strongly recommending that this application to be prepared by a law professional, and because later on, if something was missing in this agreement, it's also missing in the court. And it will be a matter of litigation. It will be a matter of dispute instead of matter of enforcing. What we are having in this agreement currently is matter of enforcing. Matter of enforcing means that both parties have agreed already, and it's time to enforce what they have agreed on. But if this was missing from the agreement, from the marriage agreement, it will be a matter of dispute. Means that the court will take over the matter as a dispute, and they will decide on it, and they will have sessions, hearings, evidence, and as if you did nothing, as if you didn't even get married using this law. So always seek an advice on this, and always seek an assistance if you are willing to get married soon. So as I was saying, in the event that there is no agreement on the conditions or controls of such alimony or the other financial claims in marriage contract, the granting of the application and its duration shall be subject to the discretion of the judge, evaluating the following factors: the number of years of marriage, so that the larger number of years gives larger alimony, blah, blah. The age of the wife, the financial situation of each married couple, the extent of the husband's contribution in divorce, financial damages, the father. So it became a conflict. It became legal disputes. It became a matter of dispute. It is not anymore an easy matter to be solved by approving from the judge, just an approve from the judge and everything is solved. No, why? Because we forgot to set out the alimony terms and conditions in the application, and this is actually a big loss. Chapter 4, we have the custody of the children, and this is also something very, very, very interesting for me to speak about, and something new to me as well, because I never used to hear or read this word of joint custody. It's something really new. So let's read what it says. It says that the custody of children is a joint and equal right for both the father and the mother after the occurrence of the divorce. It is also a right for the children not to live under the control of a single parent without the other, for raising and dealing with the child. In order to preserve the psychological health of the child in custody and limit the effects of divorce on the children. A general principle in the custody of the children is the participation of the father and the mother together in the responsibility of raising the children after the divorce, unless the two parties submit a request to the court to establish custody for the parent who is worthy of fulfilling the interests of the child subject to custody. One of them submits a written waiver to the court of his right to custody, and the other gets the right to custody. So what we want to understand from here is that there is a general rule, a principal rule, is that the custody is a joint right. However, there is an exception, and this exception could be done through an application submitted to the concerned judge that this party is dropping his right of custody. In this case, the other party takes full custody of the child. And definitely something very important that I want to add, in this case, and if either of the parties decided so, this application should also include timings of visits to the children, because basically if you didn't add timing for visit, the other party can take over the children, can take over the custody 100%. Under the current laws and regulations, aside from this law, there is a divorce, and then a custody goes to the mother. The father, the ex-husband, still has the right to travel ban both of them, because he's the guardianship of the child. He can travel ban the child, but under this law he can't, because he already dropped the custody, or he's a joint custody. So this law is totally different, and it should be treated in a way that it is like a piece of a soft material that you can really do whatever shapes you want. You can go with your imagination and customize your marriage contract the way you feel that it will work. So this application to drop the custody must have specific information, specific timings to see the child, the specific amounts to be paid to the child as a child support, as specific undertakings from the other party that they will do whatsoever needed to take care of the child, according to the agreement between the parties. And for sure, definitely, this Article 10.3 speaks about in case of a dispute. Let's be honest and let's talk honestly. There will be disputes, even if both parties have agreed on the terms and conditions that controls the marriage from A to Z. There will be disputes, there will be conflicts, there will be unsatisfaction at some point. And you will always remember that I have agreed to do this and I have agreed to be in this condition. But in order to fix these disputes, they give us an example here in this article. In case of a dispute between both partners over an issue related to joint custody, either parent shall be entitled to apply to the court in accordance with the relevant form to challenge the position of the other parent and ask the court to decide on the matter subject of dispute. In this case, we can say that it has been agreed that the mother will take over the custody. She's working, she's getting good salary, she's living good life, and for example, my children will have better life with her than me. And suddenly, the mother started to act weird. She, for example, she started to be alcoholic, she left her job, she lost her money, blah, blah, and she's using her children. She doesn't give them any care. At this time, you should dispute and you should save the children of what's happening or what's going on. And this is actually allowed. And you can do this through applying a form, and this form also you can get from the website, and there are forms for everything over there. And you can just sign the form and fill in the information, and you must attach a statement, 1 page or 2 page statement of claim to be attached to this form and submitted to the court. And if you reach this stage, I'm strongly recommending to visit a lawyer that can help you and can assess your points in claiming back the custody from the mother or vice versa from the husband. The court shall have the discretionary power to decide a particular course of action in the best interest of the child under custody, based on the request of either parent after divorce. So in this case, the court takes the matter very seriously, and they don't rely on whatever agreed in the agreement, and they start to reconsider for the sake of the interests of the children. This is for chapter 4, and chapter 4 is very interesting topic. I would say it is 80% of this law is chapter 4. It speaks about divorce, talks about the custody, talks about the rights between the parties, and it's very important to consider this chapter in terms of any future plans in getting married. The last chapter is chapter 5, and chapter 5 is also very interested, but in terms of states and wills and inheritance, and because as we spoke that as we said that inheritance under this law is totally different than the current regulations of inheritance and distribution of wills and distribution of properties. In this law, you can imagine that you can agree with your partner that none of us gets inheritance. None of us, our properties are separate during the marriage and after divorce. My properties, my bank account, my money is separate from yours, literally like this. So let's navigate and see what's going on. Distribution of estate. The stater shall have the right to leave a will with the entire property he owns in the state in favor of anybody he wants, in accordance with the controls specified by the executive regulations of this decree law. In this case, that it gives both parties the right to leave a will, and this will be for the entire property. In Sharia law and in the Middle East countries or GCC or Muslim countries, the will cannot go through if it's more than third of what you own. But here it gave the entire property, so 100% could be inserted into a will. In the absence of a will, half of the inheritance shall devolve to the husband or wife, and the other half shall be distributed equally among the children with no differentiation between male and female. Also, in here, in the absence of the will, the law stipulates that half of the inheritance shall devolve to the husband or wife. So also this is in total, like, against what is actually going on, and again is the current law. So this law actually modifies a lot and enhances a lot in terms of everything related to marriage, as we can see, divorce and even inheritance. In the regular situation, when somebody dies and he leaves to children, a wife, as I mentioned before, each one of them has different position. If he's a male, he gets higher. If she's a female, she gets lower. If she's wife, she's different than daughter. But here, I can see that the law thinks in a humanity way, in more humanity way, and actually on the true grounds that in case of there is no will, the wife gets 50% of what the husband left, and vice versa. The other 50% will be divided between the children equally. I could say that the reason behind this calculation is that at the stage of husband passing away or wife passing away, especially when husband passing away, wife actually needs every support could be given. And especially if there is a children, this is something very, very hard for her to keep up with. So 50% of his inheritance goes to her is actually something fair, so that she will get the needful help to raise her children. Also, the children will not forget, and the other 50% divided by them. That also closes the door for uncles, aunties, grandfather, grandmother to join into the inheritance in case the husband and wife doesn't have boy child. They have only daughter, but they don't have boy child. In our regulations, in Islamic regulations, if there is no boy child, all can go into the inheritance. Every single member of the family, far or near, can take from the inheritance. And of course, that drops the inheritance percentage for the successors in a very, very, very significant way. But in here, the way was closed, and even if they don't have a boy child, it will be divided as stated: 50% wife, 50% children whatsoever. If there is no children, the legacy shall devolve to the parents of the decade, if they are alive equally. If they are alive equally, or half of the legacy shall devolve to either of the parents in the case of the other parent has died, while the other half shall devolve to the brother and sisters thereof. In the absence of such situations, all the legacy shall devolve to either parent in absence of the testator's other parent, spouse, children, or brothers and sisters. In the event of the absence of both parents, the entire legacy shall devolve into the testator's brothers and sisters, where it shall be divided on an equal basis without differentiation between males and females. So in this case, we are assuming that there are no children behind this marriage, and in case there is no children, I see that they started with the very, very close relationship, and they started to go far away, far away, far away, until they came to uncles and aunties again. So giving the priority to be 50% wife and 50% children is actually something very good and well noticed. This is very new introduced rules, and it actually helps to save the inheritance and to save the legacy of the decade. Notwithstanding to the provisions, any of the foreigners' heirs may request the application of the law applicable to the estate in accordance with the provisions stipulated in the Civil Code, unless there is a registered will to the contrary. So we are always because this is a case of law conflict, and in this case, maybe one of the parties could stick to the Civil Code, and the applicability of the law might take us to a law conflict that we don't want to go through actually. And that's why I always recommend to have your will ready in case for any reason. And the registration process for the will is very easy. So basically, the wills of the persons governed by the provisions of this law shall be recorded in the register prepared for this purpose, in accordance with the procedures specified by the executive regulations. The married couple may fill out a will registration form during the signing of the marriage contract to indicate how the property will be distributed in the event of the death of either of them. So nothing much easier than this, and that's all. I think we had an interesting information. I wish that I gave some like a clue about what's going on with the new law. The new law is actually very, very small, and we're talking about 19 to 20 articles that govern the new law and actually stipulates a whole new era of marriage and divorce, and all of these regulations are actually came into the interest of the parties. This is actually a good gesture from the government to also consider new laws and new regulations for the non-Muslim. It gives flexibility for both, for Muslims and non-Muslims. And even for the non-Muslims who wishes to apply the Muslims' law to their marriage, it also gives the flexibility to do so. And this is something I never examined in any country. As far as my experience can tell me, that I never examined this in any GCC country, at least in Middle East. The entire Middle East doesn't have this law. And this law to be introduced in the UAE is something really phenomenal. And I would always recommend to apply this law to my non-Muslim clients that I really care about. And I would do my best to establish a happy marriage and a well-organized contract, or let's say an agreement between the parties that saves their rights in the future. So I would say that we came to end, and thank you very much. If you have any questions, I will be happy to answer.
Okay, I don't know if we have any answers.
There is a message from Nada. Thank you, Nada. I really appreciate your attendance today. Please, if you guys have any question, please go ahead. I will be happy to answer. The question from Carlota, is this law definitely, or is there more changes coming? I'm expecting more changes, actually. This law is newly introduced to the UAE. This law was first time written ever in the UAE, and definitely I'm expecting changes, minor changes, but it will not be core change. It will just be an enhancement to what we have in our hand right now. Nada, if I was married in Europe with another European before this law will not be applicable, unfortunately. In order to apply this law, you must get married under the provisions of this law. So if you're married in Europe, if you're married in Spain, if you're married in Qatar, you will not be able to get benefit of this law unless you're married in the UAE under this law through an application submitted to the judge. Can I apply this law for divorce, or what could be the steps to get the divorce? There are two scenarios here, Nada. Actually, if you get married under this law, yes, you can apply for a divorce under this law. But if your marriage happened outside the borders of this law, you're unfortunately allowed to get divorced under this law. You will get divorced through the regular ways of getting divorce, a legal dispute of divorce. Where can we get all the latest update? Thank you very much for your question and for your valuable time to attend. The latest updates could be watched on the latest updates about the law. I don't think there will be future updates about this law unless they issue a decree. And in order to get this decree, you need to follow on the official gazette. So I think this is not convenience for you, because you will have to follow 6 or 7 newspapers, which are the official newspapers of the UAE. So what I'm doing actually is I'm watching closely through some portals like Thomson Reuters, Lexus, these places, and also the website for Abu Dhabi Federal Court. they're also announced over there. Gulf News also announcing if there is any updates or if there is any amendments to the laws. Any more questions?
I think it was very clear, everything, Ahmed.
Yeah, all right. At the end, I would love to thank you very much indeed for your questions and your active participation in today's webinar. I hope that I have enlightened you about the new non-Muslim marriage law. And in case you have more questions, please do not hesitate to reach out to us after this session. Once again, on behalf of the Spanish Business Council and Elnaggar Partners, I'm Ahmed Gabr, and we hope to see you in more of our upcoming events. Enjoy the rest of the day, and thank you very much indeed.
Okay, thank you so much, everyone, and thank you, Ahmed. It was a pleasure to have you today here with us and to hear you. It's very interesting. Okay, so
thank you very much.
Goodbye. Have a nice day.
Thank you very much.
Bye.
Goodbye.